Welcome back to Real Estate 101. Today we're going to continue our discussion on tax law and talk a little bit about tax considerations with real estate and bank accounts. And I'm pleased to be joined once again by Eldad Gerb of Devery Smith Frank LLP. Eldad, welcome back to the show.
Thanks for having me again, Joe.
Okay, Eldad, so I want to start today's show and I want to ask you, have you ever had any scenarios when dealing with people in regards to their real estate and bank accounts?
It's a great question, and people definitely try and arrange their tax affairs when they're getting older. So grandparents, people who are 75, 80 years old, they want to have control over their affairs today. They want to minimize tax, minimize probate, and they want to be able to provide for their family tomorrow in the most tax efficient way.
Okay, so what is probate here in Ontario?
People actually get quite scared of probate, but I'm not sure that it's necessarily for such a great reason. It's typically 1.5% of your estate. So you can imagine on $1 million estate, and that includes bank accounts, mutual funds, a condo, cash, any other types of investments, up to $1 million, that's really only $15,000 in probate fees.
Okay, so are there any issues when adding an adult child to title of property or a bank account?
There's several issues. They have to take into account the CRA, potential creditors of the child, whether or not this is in fact a trust that's supposed to be distributed as part of the will, or whether this is in fact a gift to the child. The intention of again, going back to our grandparent who's 75 or 80 years old, is incredibly important, and you have to make it very clear with your banker or accountant or your lawyer, any professional. You have to determine what is intended with that transfer of real estate or the joint tenancy and adding them to the bank account.
Okay, so what is legal versus beneficial ownership?
There's a very important distinction. Legal ownership on real estate goes to the title. If you add the child to the title, so the 50 or 60-year-old child to the title, they are the legal owners. Beneficial owner is actually just a really fancy way to say the real owner. Who lives there? Who's using the property? And so in similar terms, if we're talking about a bank account, the beneficial owner is the person who's using it, the person who's depositing money into it, paying tax on any interest or dividends earned. So you can imagine a scenario where there's a grandparent who can't tend to their affairs and they've added their adult child to a bank account, but they're still technically the beneficial owners of that bank account.
Okay, so when a parent adds an adult child to title on property or a bank account, what are the legal and tax consequences?
If a parent adds a child where the child does not live with the parent, the child technically becomes the owner of that property, or half owner if it's one child split with one parent, and then their share becomes taxable in that year. So if they gave it here in 2013, and they would have to pay tax on the grandparents' disposition of the home on any amount they earned going forward. They'd actually have a capital gains issue. There would be no tax implications to the grandparent, but on a go-forward basis, that child, because they don't live there and don't have the luxury of the primary residence exemption, would be exposing themselves to tax on any increase on the value of the real estate.
Because I guess in a sense, it almost looks like an investment.
Right, because what's happened is there's been a deemed disposition. The grandparent has quote unquote sold half of the property. And so once that half of the property has been sold, in the child's hands, who is a person who doesn't live there, it's just a straight capital gain.
Okay, so based on what we just discussed, in the child's hands, what is the real estate considered?
The real estate can be considered one of two things, either a gift or a resulting trust. Now, a resulting trust is very simple. Everybody can make a trust. Again, it's one of these legal things that people make more of than they need to. There's formal trusts and informal trusts. And all you need for a trust is three things. One, you need for somebody to intend to create one. They don't have to write anything down, they just have to want to create it. The second is they actually have to transfer the property. So again, taking our example, The grandparent just transfers the title to the child, therefore they've created a trust. The third thing is there needs to be a beneficiary. So there needs to be somebody that is who is benefiting from that trust. In this case, it could be the single child after the grandparent passes away, or all of their children, or even their grandchildren that could be the beneficiaries of a trust.
All right, so what happens if it's not a trust?
Well, if it's not a trust, as we said earlier, it's a gift. Now, the problem with a gift is that, again, the child takes it in the child's hands, not the grandparent's hands. So if the child does not live in the residence or the real estate, be it a cottage, condo, or a home that they grew up in even, as long as they don't live there now, to them it's just capital property. And we know the problem with capital property is that anything that the value accrues, you have to pay tax on half of that as income. So it's very expensive to own it in the child's hands. And it in fact defeats the purpose of why the grandparent gave it to them. They gave it to them to avoid a probate fee. What they've in fact done is open them up to the tax on all of the increased value of the home.
And the capital gain.
So and they've gone and done exact opposite by gifting it to them at the present time rather than as part of their will.
All right, so what kind of evidence does a court look at in order to distinguish whether it is a trust or it's a gift?
Well, as a starting point, all gratuitous transfers are considered to be trusts, unless the person who receives the property can show evidence to the contrary that it is in fact a gift. So the items they'll look at are bank statements, they'll look at whether or not there's been a power of attorney, they will look at who has control of either the property or the bank account, and they'll look at all the other documentation before and after the transfer, namely the tax treatment of the transfer.
All right, Eldad, thanks very much for coming on today's show, and I'm looking forward to seeing you again sometime in the future.
It was a real pleasure. Thanks for having me.
So there you have it. If you're dealing with any family affairs and need the help of a tax lawyer, get in contact with Eldad Gerb of Devery Smith Frank LLP. I'm your host, Joe Tercera. Thanks for watching, and we'll see you next time.